My name is Sarah Pellenbar. I represent the appellants Teresa Gaffney and Sarah Sussman in this matter, and I'd like to reserve 5 minutes for rebuttal, please. I'm here today to ask you to reverse the trial court's default judgment, which was entered as a sanction against the appellants for their inadequate participation in discovery. Typically in this sort of case, we'd come in and we'd argue, well, the punishment doesn't fit the crime, that the sanctions were too harsh given the behavior of the appellants. However, we believe in this case that the appellant's behavior is really irrelevant because of two reasons. First of all, there wasn't subject matter jurisdiction in the case. And second of all, because the plaintiff failed to state a valid cause of action in this case. And courts have essentially held that parties shouldn't be granted relief on judgments that are not supported by the pleadings or the substantive law applicable to those pleadings. So to talk first about subject matter jurisdiction.
Well, the circuit court had jurisdiction over this kind of probate matter.
And Your Honor,
Your argument, as I understand it, is because it is purportedly an inter vivos transfer, that automatically ousts the circuit court.
It's because the court had no jurisdiction over the property at issue. Because what happened in this case...
There's a dispute as to where that property properly belongs.
Well, that's not... I disagree with you. What happened is Mr. Bauman went to the probate court, asked for permission to recover the property. He then went to the trial court, filed an action to recover the property, and then he recovered the property. However, the deed itself is indicative of who owns that property, unless there's some sort of argument that the deed is invalid. And if you look at his complaint, what he argues, he argues essentially his whole argument is on a breach of an oral agreement. We've got...
I'm sorry, go ahead.
We've got the breach of oral trust and declaratory oral trust. Those causes of action ask for damages based on her refusal to return this property. The fraudulent inducement claim is really a disguised claim for breach of oral trust, but it also asks for damages. It doesn't try to seek to invalidate that original deed. And then the exploitation claim itself, if you look at the exploitation statute, you're only allowed to get damages. You're not allowed to get sort of this equitable relief under the exploitation statute. So he never challenges the original deed, and that's where we had the problem with the case.
Well, if that's the case, why would the court need jurisdiction over the property?
Well, because it took the property and it gave it to the estate, and that's where we had the problem.
My recollection, and correct me, but my recollection is the complaint sought either the recovery of the property or the fair market value of the property. Is that right?
Our issue was in terms of what was accomplished in this.
No, I understand, but if you're talking about invoking the trial court's subject matter jurisdiction.
Well, I suppose some of the claims, if he'd had straight damages claims, we might have had more compliant appellants in the case. But they're trying to seize a property that they're not challenging as being invalid, and that's where we felt there was a lack of subject matter jurisdiction. I think beyond that, if you look at the trial court's ultimate default judgment in the case, it rules solely under the exploitation statute as a basis for returning this property to the estate. That exploitation statute, like I said, allows you to recover, quote, actual and punitive damages. Doesn't allow you to return the property to the estate. So I would argue that the default judgment alone is beyond the scope of the trial court's subject matter jurisdiction.
So it sounds like you're trying to find a way to argue that it was beyond the court's power to transfer this property.
Correct, Your Honor.
And you've just couched it in terms of subject matter jurisdiction?
Well, we'll couch it in terms of subject matter jurisdiction or failure to state a cause of action. Either way, I think that the default judgment and the sanctions order should not stand. Moving on to failure to state a cause of action, there are many cases in which a party fails to respond to a complaint. Typically what happens is you might get a default judgment entered against you, and you come back and you demonstrate excusable neglect, and you can seek relief from that default judgment. However, courts have now held that if the original complaint fails to state a valid cause of action, you don't have to come in and show excusable neglect. You can just come in and show that you failed to state that the plaintiff failed to state a cause of action and obtain relief without even referencing your behavior. So you can be as defiant or as willfully contumacious and just say, I'm not going to respond to this complaint. I think it's a load of baloney. I'm not going to deal with it. And you can get relief from default judgment. We are further along in the process, of course. We did answer the complaint. We did put up arguments as to why this should not be in court. However, the rationale is the same in the sense that courts are allowed to sanction defendants for failure to participate in discovery to move the process along. So typically, if they have an argument on their case where there's a dispute over a fact and we're not responding, well, of course they deserve relief from that. That's not the situation here, though. This is a situation where they did not have a valid cause of action to begin with. There would have been no use of proceeding with discovery, and I think that's the difference. And
So your test is, if your client decides this is a frivolous case, your client can tell the judge, I don't care how many orders you enter, I'm not showing up for my deposition. Is that the test?
and I understand that that's a harsh reality. I do think
That's what went on.
that is what went on. I think that it was sort of a snowball that got out of control down a mountain, because I think the court refused to hear our claims on failure to state a cause of action. We weren't allowed to present our arguments. Because of that, I believe the clients were sort of, their hands were tied, essentially. But I do believe...
Well, no more so than when someone is sanctioned for contempt for disobedience of a court order, and the law is, even if you think it's wrong, you have to...
That is true, but I do also believe that courts have prioritized the policy in ensuring that plaintiffs file valid complaints in the first place, ensuring there's jurisdiction. And all orders coming out of a case that lacks jurisdiction are void. The same principle is true for failure to state a cause of action. There's a higher interest in making sure that people don't seek recovery or obtain recovery in this case on completely meritless cases. That, I believe, trumps the bad behavior.
That's why you have appellate courts. Your test really seems to create chaos.
Well, there's the test on refusing to respond to a complaint, Your Honor, would create chaos, because then nobody, I mean, what you're telling me is that these clients should have just not responded at all and should have sat back and never responded to the complaint. They tried.
Well, the defaults are, people for whatever reason don't respond to a complaint, and, it plays out in a motion to vacate. But I guess I'm having trouble with the notion that a judge orders your clients to engage in certain discovery, and they thumb their nose because they have unilaterally considered the complaint to be meritless.
And I understand.
I have a hard time understanding that that's the way the process is supposed to work.
Well, again, in the context of refusing to respond to a complaint, you can thumb your nose at the judge and thumb your nose at the judicial system and say, I'm not going to respond to this because there's not a valid cause of action. And it's certainly a risk, Your Honor. I mean, it's a huge risk. But if there's no valid cause of action in the first place, and there's no subject matter jurisdiction, the bottom line is that the plaintiff should not be entitled to relief. And I want to read to you from...
But it's not because you decide, your client decides that this is a frivolous case, that does not create an immunity from proceeding, does it?
It creates only an immunity if there's a failure to state a cause of action and there's lack of jurisdiction. Or if there's a lack of jurisdiction. I want to read to you from the Becerra case, because this is one of the cases that I think is relevant. Failure to state a valid cause of action is a fatal pleading deficiency not cured by default judgment. A default judgment should be set aside where the complaint on its face fails to state a cause of action. By default, defendant admits the sufficient allegations but is not deprived of the right to challenge by appeal a material pleading deficiency. And in reaching the question of whether a default judgment should be set aside where the complaint fails to state a cause of action, courts find it unnecessary to decide whether the defendant otherwise set forth good grounds for failing to respond to the complaint. We understand that's in a different context, but I think the concerns that you're expressing now, Judge LaRose, are apply to that context as well as this context. I think it's a risk that clients take. However, if there's no valid cause of action in the first place,
why is there
the law
not?
requires the default judgment to be reversed.
Why is there not? Let me go back a little bit. Your whole argument is based upon the fact that there was no cause of action pled, lawful cause of action pled. Why was there not? Wasn't the lawsuit to set aside the deed, the inter vivos deed, based upon the exploitation?
Well, there were several counts in the complaint, but we believe all the...
Wasn't there a declaratory also?
There was. There was a claim for breach of oral trust, declaratory oral trust. There was an exploitation claim and a fraudulent inducement claim with regard to this trade.
But the entire real cause of action was based upon setting aside the inter vivos deed based upon her actions?
They rely on language in the will that says two things. It says, Mr. Gaffney says, I'm transferring this property to Teresa Gaffney to keep the property away from the two other sisters. It then says, at the time of my death, the property will be liquidated, expenses will be paid, and any remaining proceeds will go to the church. That's a complete, if that represents a promise that was made, that's a complete oral promise that Teresa Gaffney and Mr. Gaffney had, and it's barred by the statute of frauds, which says that if you have if no action shall be brought upon any contract for the sale of land.
But that's a
unless it's in
defensive
writing.
matter, assuming there is a cause of action pled to begin with.
The law states that if statute of frauds appears, if the defense of statute of frauds appears from looking at the complaint, if you can knock this case out by looking at the complaint and see the statute of frauds applies as a matter of law, then you can assert that claim as a failure to state a cause of action.
Correct.
And essentially, the case is
But your
invalid.
argument is there was no cause of action actually pled, and there was no subject matter jurisdiction.
Well, those are separate arguments. I think this is sort of we agree there is no subject matter jurisdiction. This is sort of an alternative argument that what he's asserted is not supported by the law because it's invalid under the statute of frauds and it's invalid under the statute of limitations. And there's cases specifically on.
And that would apply to the exploitation claim as well?
Yes, Your Honor. I think.
Hey, would you just elaborate on that one for me, please?
Sure. Well, the statute of frauds is pretty clear. It says no action shall be brought upon any contract for the sale of lands unless it's in writing. I think that would, by its definition, apply to. And
that would include, so your point is this oral contract was the basis for every count?
Every count.
And because of the statute of frauds, that eliminates each
Correct.
count?
In fact, their evidence of exploitation in this case is that she
Is
transferred the
only
property
the
with-
oral contract?
It's only the oral contract. That's all they've alleged. So that's where we
So
have.
what they've done is they've taken this allegation of an oral contract and they've converted it into, 5 or 6 different counts?
Correct.
Oral, a trust and
Correct.
constructed
And the breach of trust is
released.
probably the only legitimate count that really makes sense given the facts they're alleging. However, that's barred clearly by the statute of frauds. In terms of trying to rephrase this as a claim for fraudulent inducement, there are courts, including the India Trading versus White case, that says you can't couch a breach of an oral contract as a claim for fraudulent inducement.
Was there, I can't recall, was there any request for specific enforcement in the complaint? I don't recall.
Well, the entire complaint asks for either damages for the value of the property.
Right.
Or to return the property to the estate. So that's, if you look at this, at what they're basing this on, they're reading this promise. We read the promise a little differently. We read the promise as, well, if there is a promise that Teresa Gaffney is basically using this house, can pay off the expenses as she's taking care of her father. If there's any money left over, she'll give it to the church. She worked this out with the church. The church wasn't interested anymore. They disclaimed any interest in the property. She feels like she's done exactly what was required by her father, or what he wished for her. Their interpretation of the promise is that she was required to either return the property to the estate and let them sell it and deal with it from there, or essentially give the value of the property to the estate, regardless of how you interpret it.
And then
it's
file
breach of an
her
oral
claim
promise.
in the estate and be paid out of
Right.
that. And
Regardless, they're trying to enforce this promise that she made. And
well, it did say, I think in the will, to pay expenses, including care. So it wasn't just.
Yes. It encompassed.
That does support the notion that the proceeds from the sale would have gone into the estate to pay expenses, as well as her claim.
Well, I would.
And I understand you're saying that what's in the will that's not the promise.
Well, the language in the will says that the proceeds will be distributed at the convenience of Teresa Gaffney. So I think that affords her
That's true.
a lot of
That's true.
discretion
Right.
in how she distributes those proceeds, if there are any. Her position is she took care of him the last several years of his life. It was expensive. The property's honestly not worth that much money. I think it's like $109,000, something around there. And there were no money. There was no money left. So in that regard, to sort of follow up on your point, statute of limitations, in addition to statute of frauds, also from the face of the complaint, this is clearly the enforcement of her promise that she allegedly made, that specific performance. They asked for specific performance. They asked for either the value of the property or the return of the property based on what she promised in this contract. And for that reason, we believe that the case is subject to a one-year statute of limitations that they have not met. Alternatively, we've got a 4-year statute of limitations period. The deed was recorded 5 years prior to the filing of the action. Again, the statute of limitations has run. Well, they say they didn't discover the fraud or the exploitation until she transferred the property to her sister. Of course, she did that once the church disclaimed any interest in the property. But regardless, they didn't discover anything when that happened. There's no evidence of fraudulent inducement. Any kind of claim they have has long since passed the time for filing. And for those reasons, we believe that the plaintiff failed to state a cause of action, first of all, based on statute of fraud, and second of all, based on the statute of limitations. So ultimately, legally, we believe there was no basis for the lawsuit in the case. There was no subject matter jurisdiction. The plaintiff failed to state a valid cause of action. They should not be entitled to relief on a non-existent case. And for those reasons, we would respectfully ask that you reverse the default judgment and the sanctions orders that were issued in the case.
Thank you.
Thank you.
You'll have about 4 minutes for rebuttal.
May it please the court. My name is Michael Kangas. I represent Philip Bauman as the administrator ad litem of the estate of John Gaffney. The issues here are pretty clear, and I think it's clear this court must affirm this judgment. With respect to subject matter jurisdiction, I don't think there's any dispute about what subject matter jurisdiction is, and I think Judge Laura's hit it on the head. It is the ability to preside over that class of cases. And I think we've got to look at the briefs, because I think there was arguments made today outside the briefs that were filed with this court, especially the initial brief filed by the appellants. Their argument as to subject matter jurisdiction is summed up in 2 sentences in their brief. At page 18, they say the court never had subject matter jurisdiction in the first place because the estate had no viable claim to the property deeded by inter vivos gift while John Gaffney was still alive. And at pages 21 to 22, they state John, Mr. Gaffney that is, very simply had already transferred the property before he died, and thus at the time of his death, he no longer owned the Clark property. As a result, the estate had no legal claim to the property as a matter of law. And the fact of an inter vivos gift in death does not cut off an estate's right to go retrieve property, to look at inter vivos transfers to see if anything untoward happened, or to recover property for the estate that was misappropriated. The very cases cited by the appellants in their brief support that, and the argument that there is no subject matter jurisdiction, I think, is a bit absurd here. The theory offered here today is that when a person dies, no one can challenge his or her lifetime transfers, and that is not the law in the state of Florida or any other state that I'm aware of. I limited...
You have to tee up your claim properly.
I understand that. And,
I think that's one of the things I'm hearing is the claim really wasn't teed up properly.
Well, I would respectfully disagree with that, Your Honor. There's never been an allegation that we never alleged facts to support every element of the cause of action for exploitation or fraudulent transfer. That's what the lower court ruled upon. So I'm going to limit my argument to those 2. But there's never been an allegation in this court or any brief or the court below that we did not state every essential element to that cause of action. What appellants do is they conflate the issue of raising an affirmative defense by motion to dismiss as a motion to dismiss for failure to state a cause of action. And if we want to look at that, we've got to go back and look at the rules. And Rule 1.110D clearly states, unambiguously, affirmative defenses appearing on the face of a prior pleading may be asserted as grounds for a motion or defense under Rule 1.140B, semicolon. 1.140B governs defenses. B is how they're presented. It says every defense in law or fact to a claim of relief in a pleading must be asserted in the response of pleading, except these next 7 enumerated defenses can be raised by motion, and that is a type of motion that 1.110D contemplates. If the Supreme Court, in promulgating the rules of civil procedure, wanted an affirmative defense raised by motion to dismiss to be a failure to state a cause of action, they would have said that it would be asserted as grounds for a motion under Rule 1.140B6, and the rule does not state that. It's just a motion to dismiss. Every case relied upon by appellants as to vacating a default based upon failure to state a cause of action resorts to the failure to state an essential element. Not one deals with the application of an affirmative defense that may appear on the face of the pleading. And why is this, the argument has got a little bit of a illogical issue to it, because if this court is to accept that argument, that means every time in the state of Florida a judge enters a default judgment, they must pick through the allegations in the pleading and determine whether those allegations support any affirmative defense, not just statute of frauds, not just statute of limitations, and what...
No, it means that they have to determine whether one that has been raised.
Well, take it to a normal default situation where the defendant has not responded. So I sue you for negligence, 5 years
Well, when
after...
they come in to move to set aside the default, they have to raise something.
Well, the issue
I
is...
mean, it doesn't spontaneously happen.
Well, it does not create a
And
failure...
why don't you address the issue of the statute of frauds in the oral contract?
Well, my first argument with respect to the statute of frauds is all defenses have been stricken. The lower court sanctions struck their pleadings and entered a default against them. They weren't allowed to defend.
You're trying to get that set aside.
I understand that.
And one of the reasons that they're asserting is that the complaint on its face relies on the existence of an oral contract that would be barred by the statute of frauds, and therefore you could never recover under any count in your complaint.
Well, the statute
So
of
how
frauds...
about addressing that?
I'm sorry. The statute of frauds, Your Honor, requires that it either be supported by a written contract or some note or memorandum signed by the person against whom it's going to be enforced. And attached to our complaint at Record 41 is a letter from Ms. Gaffney acknowledging the promises she made to her father. So there's a writing. The other thing we've alleged here is that there was an agreement between the two of them.
Well, you've alleged an oral agreement.
Well, I think if you look at the complaint as a whole,
You've alleged an oral promise between Ms. Gaffney and her father.
Yes, I understand that.
You're not proceeding on her promises with the church and her alleged contract with the church, which would be what that letter represents.
I respectfully disagree, Your Honor. If you were to look at the allegations of the complaint...
I did look at the allegations of the complaint.
When we attach that writing, we acknowledge it as an admission of her promises. There is a writing to enforce.
Her oral promises to her father.
Well, Your Honor,
That contract is not in writing, is it? The one between her and her father?
all you need is a note or memorandum acknowledging the promises, and that's what we have, is a writing signed by Teresa Gaffney. It is enforceable. Whether there was a contract there or not, I mean, you've got a deed that says for other good and valuable consideration. That was those promises. And the other thing is the cases on the statute of frauds.
So in your complaint then, why did you allege that it was an oral promise?
I mean, it was both oral and then she acknowledged it later in writing.
No, I'm asking you why you alleged an oral promise in your complaint.
Because there was an oral conversation between the two of them that she later acknowledged in writing. And that's the position raised in our complaint. I think the other issue is that that does not create a failure to state a cause of action. Oh, and back to that, the other thing is we've alleged that John Gaffney transferred that based upon promises. And the case law that we've cited to in our brief clearly states that once a party to a contract has fully performed, the statute of frauds doesn't apply. So we've got three arguments there. There is a writing, it didn't apply, and it's not a failure to state a cause of action. It's an affirmative defense that must be raised by motion. And affirmative defenses in this case were stricken as a sanction against Ms. Gaffney and her daughter for their contumacious and deliberate disregard of the court's orders.
Well, that's circular because we're here about getting that set aside.
Well, I disagree, Your Honor, because in order to get that set aside, they have to have the sanctions order set aside. And they've not shown any abuse of discretion to this court and the court sanctions. I mean, the default was entered as a sanction. So not only do they have to show that they have a way to get around the default, they also have to show a way to get around the sanctions order. You can't just put the sanctions order aside. I would agree that if the court determined there was no subject matter jurisdiction, the sanctions order would not stand. But to rely upon just to say, oh, the sanctions order doesn't matter, let's see if these are defenses, they first have to be able to raise those defenses. And they're not allowed to right now because they've been prohibited from pleading in response based upon their contumacious and deliberate disregard for the court's orders and the court's authority.
Do you want to address the statute of limitations issue?
Yes, Your Honor. with respect to the statute of limitations, the 4-year statute, we've clearly alleged the complaint. We've got to look at the 4 corners of the complaint in determining a default.
Well, you didn't want to look at the 4 corners of the complaint when we started talking about an oral contract, but go ahead.
Well, if you look at the 4 corners of the complaint, we clearly allege that there was the delayed discovery. Today, in argument, and in the brief, there's an argument about some disclaimer by the church and some contract. That's not attached to the complaint. That is not information that this court can consider in determining whether we stated a cause of action and whether the statute of limitations applies. It is alleged that we didn't discover Ms. Gaffney's breach or her deceit until she gave the property to her daughter, rather than distributing it like she had agreed to, that is stated in her oral promises acknowledged in writing that are attached at Record 41. The idea that there was some other agreement between the church is not part of the complaint. That they didn't present that evidence at trial because their pleadings were stricken.
You just referenced it as an attachment to your complaint.
No, my Record 41 is my attachment. That's Teresa Gaffney's promise. What the appellants rely upon.
Which was the letter to the church?
Yes.
Is that what you were referencing?
No, there's a separate letter to the church.
There were 2 letters to the church that I saw.
But there's a separate letter that's not attached to the complaint that is relied upon by appellants. That was some agreement after John Gaffney's death that the church allegedly gave up their rights. But that is, number one, it's not signed by somebody authorized by the church, but we don't even need to go there because it's not part of the complaint or the 4 corners of the complaint in determining whether there was a delayed discovery. There's no way to determine that she was not going to honor her promises until she transferred it to her daughter. And I understand that the court, one of the judges up here, commented on that at the convenience of Teresa Gaffney.
Right.
Well, it was no longer at her convenience once she gave the property away to somebody that was, or fraudulently transferred it to somebody that wasn't entitled to it. So for all of those reasons, I think if you can go back and look at the cases we cited in the reply brief, there's 7 of them about this failure to state a cause of action issue, and not one of them mentions a failure to state a cause of action. They say it can be brought as a motion to dismiss under Rule 1.140D. Which is a 1.140B motion. It's not a B6 motion, which is failure to state a cause of action.
And you can raise that even at trial.
I understand you can raise failure to state a cause of action, but that's not a failure to state a cause of action, is what I'm telling you. If you look at the rules clearly state, there's multiple cases on construction of rules and statutes, they both apply. If the rules are unambiguous, you apply their plain meaning.
Well, the rules also say that you should be given liberal leave to amend, and they weren't allowed to amend their affirmative defenses.
Well, even if you look at the affirmative defenses as amended, I think that one of the pleadings that was stricken as unauthorized, I think it's at Record 576 to 577, they didn't raise the statute of frauds as to exploitation. They didn't raise the statute of frauds as to fraudulent transfer. They didn't raise the statute of limitations as to those counts. If you look at the pleadings, but regardless of what they've raised or not, the pleadings were stricken. There's no affirmative defenses allowed to be raised unless they overcome the sanctions order, which they have not. They've not shown this court an abuse of discretion by the lower court. And because of that, this court must affirm. Unless the court has any other questions for me, I'd surrender the rest of my time.
Thank you, Mr. Kangas. Ms. Pallenberg?
Your Honors, just briefly on failure to state a valid cause of action. There are 2 cases I want to mention. The Myers case, which we mentioned, we have this in our initial brief. It distinguishes a claim for statute of frauds asserted as an affirmative defense versus a claim asserted for statute of frauds as a failure to state a cause of action. There's another case, the Hanano case, which says that generally statute of limitations is affirmative defense. But if this defense appears on the face of the pleadings, it can be asserted as a claim for failure to state a cause of action up until trial. What the trial court did here is it said when we tried to amend our affirmative defenses to assert some of these claims, the trial court said, you have waived these claims of, quote, failure to state a cause of action. So at that point, the clients believe they're not going to listen to us. We ended up filing a summary judgment motion trying to rephrase these arguments as a summary judgment before discovery had begun. And the court ended up never even ruling on that summary judgment motion. It just simply wasn't going to hear any claim for failure to state a cause of action. And in that regard, Judge LaRose, I think I understand your concern about sort of encouraging bad behavior. but at the same time, I think that this is something that is rare. I think it's going to be rare in a situation where a court is going to refuse to consider a defendant's arguments on failure to state a cause of action, which is going to cause the snowball effect, and they're going to have these defiant people who are not going to participate in discovery. I don't think that's really going to ever happen much, so I don't think there's as much of a concern as you're expressing. And ultimately, I do believe that...
That seems to be how you're framing your issue on that is, you have to look at this conduct in this context.
Exactly. It's sort of a specific
This didn't happen in a
situation.
vacuum.
It didn't happen in a vacuum. And of course, there's a stronger policy on simply encouraging people to file valid claims in the first place. And that's where we have a big problem. Just briefly, on the statute of frauds, they reference this letter between Miss Gaffney and Monsignor Daly, who's a representative from the church. There is a letter. It's a separate letter. It has nothing to do with her and John Gaffney and this oral promise with John Gaffney. It's a separate letter signed by both saying that she intends to distribute the proceeds. And then there's an amended letter several months later signed by both parties saying that, in fact, she's already spent all of the money on her own expenses, and both parties, including the church, agree that she doesn't owe the church any more money. So frankly, this was taken care of between Miss Gaffney and the church, which seems to be her father's intentions in the very first place. So ultimately, we believe that's really a non-issue. In the end, if you are to consider Cazell, I would just argue that all of these legal issues go to sort of the reasonableness of their failure to participate in discovery, and I would just ask you to consider the severity of the sanction. The court took homesteaded property away from this Ms. Sussman. It was a significant sanction compared with the weakness of their case and of course our client's attempt to try to get these legal issues before the judge. And then also maybe consider what John Gaffney wanted in this case. I mean, he clearly wanted the money to go to the church. The two parties have worked that out. He didn't necessarily he disinherited two of his other daughters, including the attorney who's here today, not Mr. Kangas, but the appellee who is the attorney for one of the disinherited daughters is now trying to recover his attorney's fees, and that's the whole basis of this lawsuit.
Well, yeah, this puts money into the estate from which he has a claim for fees.
Correct.
Yeah.
Correct. So for those reasons, we would ask you to reverse the default judgment and the sanctions order in this case. Thank you.
Thank you.